Good afternoon, and I'm very happy to call to order the Standing Committee on Public Safety and National Security Committee's 49th meeting in this Parliament, and welcome our guests. And I just want to welcome Mr. Abultaif and Mr. Vandel as full members of our committee today. We're glad to see you. And also welcome Minister Goodale, and thank you for accepting our invitation to help the committee, and it's pursuant to Standing Order 108(2), study of the subject matter of Supplementary Estimates B for 2016 and 17. We'll be considering the supplementary estimates. Just a reminder to the committee that due to scheduling, we were not able to consider the Sup B estimates prior to them having been deemed accepted by us and already reported to Parliament. However, not ever wanting to miss an opportunity to spend time with the Minister, we are very pleased that he's able to be with us. So the topic of the first hour is the Sup B estimates and other issues related to those, which I'm sure will arise. In our second hour of the meeting, we'll continue with Mr. Colomb and CSIS and discuss recent events in the Noel decision in the federal court. Obviously, that you can ask questions to anybody, but I'm thinking that if we could keep most of those questions for Mr. Colomb to the second hour, it would probably be somewhat more efficient, but the time is yours. I just wanted to draw your attention and to thank the analysts for their work on the working document, the Issues and Options paper on Canada's National Security Framework, which was sent to committee members this afternoon. So just to check your inbox and take a look at the Issues and Options papers. I've not had a chance to look at it yet, but in advance I know it'll be good work, so thank the analysts for their work. Any other things I need to say? Okay. Mr. Goodale, the floor is yours.
Well, thank you very much, Mr. Chairman, members of the committee. Thank you for the invitation to be here today, particularly on Supplementary Estimates B. I'm very pleased to be joined by most of the usual cast of characters here today. My Deputy Minister, Malcolm Brown, Michelle Colomb, the Director of CSIS, Commissioner Paulson, from the RCMP, Carolyn Xavier, who is Vice President of Operations at the Canada Border Services Agency. I would point out that the former President, Linda Lizotte-McPherson, has retired as of last Friday, and her replacement is in the process now of arriving, John Osowski, and he will no doubt have the pleasure of appearing before the committee on future occasions. In the meantime, Carolyn is representing CBSA today. Fraser McCauley, Assistant Commissioner with Corrections Canada, is also here, and Harvey Senenko, the Chairperson of the Parole Board of Canada. As you will note from studying the estimates B, the Department portfolio of public safety is requesting adjustments that result in an increase in our spending authorities of $256.3 million. And I would like to run through very briefly what those items are that add up to that total. Canada is, as you know, a safe and peaceful country, but we also know that we are not immune to threats, including natural disasters, terrorism, and other crimes and acts of violence. The women and men of the public safety portfolio, including the department itself and all of the various agencies that you see represented here today, do the essential and often dangerous work of protecting Canadians, and for so doing they deserve, and I believe they have, our admiration and our gratitude. It's up to us as parliamentarians to support them and their work so that they can continue keeping Canadians safe and protecting the rights and freedoms that we all hold very dear. The items included in the estimates are directed toward that end. First of all, let me deal with Fort McMurray. As you know, we faced a terrible fire disaster there earlier this year, probably the worst in Canadian history. In coordinating the federal response to that disaster, I got to see some pretty remarkable things, including the courage of the people of Fort McMurray, the determined leadership of local, provincial, and federal officials, the skill and the selflessness of firefighters, police officers, and other first responders, and the tireless efforts of the Canadian Red Cross. And of course, from coast to coast, Canadians gave generously to support those who were so seriously affected. The Government of Canada has transferred $104.5 million to the Canadian Red Cross, honouring the Prime Minister's commitment to match the individual charitable donations that were made by Canadians in support of Fort McMurray. That, Mr. Chair, accounts for a large portion of the total authorities that are being requested today, those matching funds for the Red Cross. You will also know that under the disaster financial assistance arrangements, we made an advance payment to Alberta of $307 million as a down payment on what will be the ultimate obligation to assist Alberta in dealing with this disaster. That amount of money is not in these estimates because it is covered in the main estimates. Every year there's an allotment for the DFAA, and that is covered. The amount that's required for Alberta is covered in the allotment in the main estimates. So the SUPs deal with the matching money for the Red Cross, $104.5 million. Second topic is HUSAR, the heavy urban search and rescue teams. That capacity in Canada is something that we mentioned in our election platform, that we would reinstate federal funding to support the HUSAR teams across Canada. They are absolutely indispensable in responding to emergencies like ice storms, floods, wildfires, and building collapses, and so forth. The previous government made a decision at one point to eliminate that funding. We decided it was of sufficient priority that it needed to be reinstated. So in October, I was pleased to deliver on the commitment that we had made by launching the Heavy Urban Search and Rescue Program, which will provide $3.1 million annually in funding for these heavy urban search and rescue task forces. This program will not only support and strengthen the 4 existing task forces in Vancouver, Calgary, Brandon, and Toronto, but they will also help to develop new capabilities in Montreal and to reestablish capabilities in Halifax. To this end, $3.1 million is being sought through Supplementary Estimates B. The third major topic is RCMP class actions. Another part of the mandate that I received from the Prime Minister was to take action to ensure that all parts of the public safety portfolio are healthy workplaces free from all forms of harassment. And I've been working on this from the very beginning of our mandate, notably inviting the Civilian Review and Complaints Commission for the RCMP to undertake a comprehensive review of RCMP policies and procedures on harassment, and also appointing Sheila Fraser as a special advisor to examine the RCMP's complaint process and the treatment of complainants. And that work is ongoing. I expect to hear from both of those processes sometime next spring. I was also very pleased to join Commissioner Paulson on October the 6th for the announcement of a $100 million settlement between the RCMP and a large number of plaintiffs in 2 proposed harassment-related class action lawsuits, of which $40 million is being sought through these 2016-17 Supplementary Estimates B. The remaining $60 million will be accessed in the following year. In addition to the $40 million for actual payments for settlement, there is another $17 million for class action counsel and claims assessment. That's being sought through these estimates too. So the total number required to deal with the class actions is $40 million plus $17 million for a total of $57. I think we should be encouraged by this development and by the eloquent apology that was offered by the Commissioner while we continue to advance other initiatives on this very important front of safe workplaces. This is an important step in helping us move forward from a deeply troubling aspect of the history of our national police force to a much different future. In terms of the claims process, I think it's important to highlight that there has been set up totally separate and apart from government, totally separate and apart from the force, an independent process to actually adjudicate the claims. The RCMP will have no involvement except to make available documentation. The government will have no involvement except to provide the funding. The decisions will be made by the Honourable Michel Bastarache, a former Justice of the Supreme Court of Canada, who is the independent assessor, and he will make the determinations of the appropriate amounts case by case by case. Mr. Chair, on national security, the government continues its work to ensure that Canada's national security framework keeps Canadians safe while safeguarding our rights and freedoms, and I'm pleased to report that the unprecedented engagement with Canadians that we have launched right across this country has been very successful, including a series of town hall meetings, roundtables, public hearings, personal discussions, and meetings with subject matter experts, as well as quite literally tens of thousands of contributions coming in via email in our online consultations. That consultation remains open until December the 15th, but already the total number of participants is in excess of 45,000 Canadians. It's a very encouraging number. Once again, let me thank the committee as well for the hearings that you held and the report that you will make about the advice you would offer the government in relation to the national security framework. We are analyzing all of the input and we will be putting forward a set of measures that will be designed to achieve two objectives simultaneously: protecting the public, keeping them safe and secure, and at the same time safeguarding the rights and freedoms of Canadians in a free, inclusive, and democratic society. I also want to note the work the committee has done on Bill C-22. I understand it's now in the process of being reported back to the House, and I will be very anxious to consider that report. One other matter under national security that involves an estimate in these supplementary estimates B, and that is the creation of the Office for Community Outreach and Counter-Radicalization to Violence. You will know that was an item that was earmarked in the budget last spring, and to this end, you will note that in these estimates, my department is seeking $2.3 million in 2016-17 to establish and staff the office, as well as supporting the domestic programming and research initiatives through a newly established grants and contribution program called the Community Resilience Fund. The office will provide leadership on Canada's response to radicalization to violence, coordinate domestic and international initiatives, support programming and research, and enhance our expertise. We simply must become very good at this initiative if we want to retain that fundamental character of Canada as an open, inclusive, democratic society. Immigration detention is another item that I want to mention today, Mr. Chair. We are requesting $22.7 million this fiscal year to support the Canada Border Services Agency in its implementation of our new National Immigration Detention Framework. A total of $138 million for this initiative was announced in August, spread over a number of years. In this first year, we're asking for $22.7. The goals of the new framework include expanding practical, workable alternatives to detention. Secondly, significantly improving conditions at immigration holding centres, including better mental and medical health services. Thirdly, reducing our reliance on provincial facilities. And fourth, reducing the number of minors in detention to the greatest extent possible. Of the funding that's being requested for this year, $21.3 million is being directed to the construction of new immigration holding centres in Laval, Quebec, and in Surrey, British Columbia. These facilities will help reduce the reliance on provincial correctional facilities for immigration detention. The balance of the funding this year will be used to begin enhancing medical services within our immigration holding centres and to implementing alternatives to detention so that, as much as possible, immigration detention remains a measure of last resort and not first resort. So, Mr. Chair, a great deal is underway. A good many things have been achieved, but there is, of course, always much more to be done. My officials and I are happy to try to respond to your questions today, and we look forward to working with the committee on a whole array of national security issues for the future. Thank you.
Thank you, Minister. And for the first round of questioning, we begin with Mr. Spengeman.
Thank you very much, Mr. Chair. Mr. Goodell, nice to see you. Good to have you and your team back in front of the committee. And I'd like to take you to your last submission and ask you to give us a bit more of a fine-grained view of your vision for the immigration detention facilities and the changes there too. And is this analysis one that's driven by numbers? Is it driven by qualitative differences or challenges that you've alluded to in terms of youth being detained? And how do you see this framework evolve over, let's say, the next 5 years?
Well, there are only 3 federal immigration holding centres in Canada. In Surrey, British Columbia, right at the airport actually, in Richmond in BC, in Laval, Quebec, and in Toronto. Those are the largest intake centres for newcomers arriving in Canada, so logically the federal facilities would be there. They are often overtaxed in terms of volume, and the next resort is to rely upon provincial correctional facilities in the neighbourhood to deal with people where detention is the only alternative. The numbers we feel in these various federal and provincial facilities are simply too high, and we believe that the provincial facilities in particular are problematic because they are correctional facilities, and the people who are being detained for immigration purposes are intermingled.
So there's a stigma issue, if I can interrupt.
Yes, there is, and we want to get rid of that as much as possible. The reason for detention is really only in 3 particular cases where there is a real problem in identifying who the person is, and identification is obviously a critical factor in assessing safety considerations, and often CBSA is not able, with the information available to them, to precisely identify the individual. So if there's an identification issue, if there is a flight risk, or if there is a serious risk to the public, then detention becomes an alternative that CBSA can consider as a last resort. The problem with the circumstances of the past and up to now is that there aren't very many other resorts to consider. So detention too often becomes the default mechanism. So we want to improve these facilities, the 3 facilities, to make sure that they can handle more people in a better way and take the reliance off of the provincial correctional facilities. Secondly, make sure that in those federal holding centres, that the appropriate mental health and physical health services are available, that legal counseling and other counseling is available, that inspections can be done by the Red Cross and by the UN High Commission on Refugees as and when necessary at their discretion. And we also want to make sure that there are other physical alternatives to detention. So we're discussing with a whole variety of immigrant support organizations what those alternatives might be. The Toronto Bail Program, for example, has been used as a good example of what an alternative might look like. There may be electronic means of voice identification, new technology, for example, that could be of assistance. So that CBSA officers will have a broader array of alternatives to look at, to keep the public safe and to make sure that refugees are treated, the people who are in the circumstances of detention are dealt with in a proper, humane way. And when it comes to children, as much as possible, we want to eliminate that altogether.
Thank you very much for that. Minister, in the transfers under public safety, there's a $41 million transfer from PSEP to the Royal Canadian Mounted Police for First Nations community policing. This committee had the correctional investigator, the former correctional investigator, Mr. Howard Sapers, before just recently to comment on the 2016 report. Could you let the committee know your vision of what needs to happen in First Nations policing? The argument we often hear is that our correctional facilities are overcrowded because of the upstream challenges that may exist. If you can just give us an update in the context of this $41 million transfer of what your thoughts are.
Both the Justice Minister and I have mandated instructions from the Prime Minister to work with all dimensions of the criminal justice system to deal with the very negative consequences of that system for a great many Indigenous people. Minister Wilson-Raybould, as you know, has a whole range of laws and procedures under consideration. One of the dimensions of it that relates to my portfolio is the First Nations policing program. That program was established in the early 1990s. The last minister to actually give it a policy facelift was Solicitor General Herb Gray in 1996. It hasn't been improved in terms of policy since that time. Give Mr. Gray a lot of credit for what he did back then, but that's over 20 years ago. It's time to bring the policy up to date. It also has not had a financial increment since 2009. The arrangement is basically a 50-50 arrangement, almost 50-50. It's 52-48 between the federal government and the provinces, where we each contribute an amount to the First Nations policing program, and then try our best to provide, in consultation with First Nations communities, good, solid policing services. But with the amount of money that's available and the policy framework that's available today, we're not nearly meeting the need. Probably not much more than half of the communities that could qualify for this kind of service actually have it. And the objective here is to bring the policy up to date so that Indigenous communities can count upon top-notch policing services that are equal in terms of standard and professionalism to the policing services that every other group of Canadians take for granted. Make sure that the cultural sensitivity is there in the way the service is delivered, and make sure that there is adequate financing on a long-term basis. And many of the First Nations have said to us, you should really think of whether or not a First Nations policing program, which implies that it's temporary, is the right way to go when you're providing a fundamental service like a police service. And maybe there should be a more comprehensive and permanent basis for the way in which all governments come together to ensure safety in First Nations communities.
Thank you for that.
Thank you, Minister. Mr. Clement.
Thank you. Good questions. Minister, for being here. I wanted to start by just allowing us to elaborate a little bit on our exchange in the House of Commons today and talk about that Canada Border Services Agency report on the Mexican drug cartels and the concern expressed in the CBSA report that by removing the visa, this in fact extends the reach of the violent drug cartels to expand into Canada. Particularly, there was concern that they would replace the fentanyl shipments that we're trying to crack down on from China with merely more cartel shipments from Mexico. So I want to give you the opportunity to respond a bit more than 35 seconds on that. It was not a concern that I was aware of before this report was made available to a journalist, an internal report of CBSA. But now it's of grave concern. We do not want to see increases in fentanyl, increased deaths because of fentanyl or any other harmful drugs in our society We don't want to see the increase in violence that normally attends with the Mexican drug cartels. So on the one hand, we have lifted, or you have lifted, the visa requirement, and on the other hand, we have this concern expressed by Canada Border Services Agency officials. So I want to give you the floor to answer more fully than we could do in Parliament.
Mr. Clement, whenever a decision is taken with respect to border arrangements, the decision is taken with a great deal of care and deliberation to make sure that all the proper analysis has been done and that we are accomplishing two objectives. Number one, a properly functioning, efficient, successful border, and number two, that all of the factors in relation to public safety and security are properly dealt with. In dealing with inflows of people from every part of the world, CBSA takes their function at the border very, very seriously. Whether or not a person arrives on Canada's shores with or without a visa, they are obviously examined at the border to determine if they can enter Canada. Coming to Canada without a visa isn't a free pass to get in. The CBSA officers do their job at the border to identify if there is any risk or danger. Does there need to be secondary clearing? Is the person admissible or inadmissible? And in all of the factors that CBSA takes into account. So all of this has been weighed very, very carefully to ensure that we have the police and the security and the CBSA resources and authorities lined up to keep Canada's borders safe and secure. And we obviously are very concerned with our colleagues in the provinces and our colleagues in law enforcement about this phenomenon that has swept across the country in the last number of months in particular related to opioids.
Sorry to cut you off, but I have a limited time, Minister. I just want to read directly from the CBSA report, which says the visa lift will make travel to Canada easier in order to establish or strengthen existing cartel smuggling chains. In the next 3 years, Mexican drug cartels are expected to expand their presence in Canada by sending operatives and recruiting local airport or marine port workers with ties to Mexico. So this is not a case of this is the natural flow of trade, and this particular section of the report looked specifically at the visa lift and said we are creating additional problems for ourselves involving the Mexican drug cartel. So your point is well taken that CBSA does what it can, but clearly they are raising red flags for all of us. And it is our responsibility to respond to those red flags. So how are you responding to those red flags?
First of all, there has been a long series of discussions with the Mexicans to ensure that we have the appropriate system in place, both in Mexico and in Canada, to keep Canadians safe and secure, and that the visa lift can be done in a way that is successful for both countries. On the Canadian end of the equation, through the good work of CBSA and law enforcement by the RCMP and others, we are putting in place the systems that will, as we always do, to protect Canada. CBSA has done its job in flagging an issue that they want themselves and the rest of government to pay careful attention to, and we are, to make sure that this can be done in a successful way.
So could I ask you, Minister, to undertake to this committee and to Parliament to continue to report to us on the efficacy of these ways and means that under your disposal and under CBSA's disposal to ensure that they are working to curtail the influence of the drug cartels? And in the alternative, can I ask you to have an undertaking with us that if, for whatever reason, those are not working to your satisfaction, that you would initiate a review of the visa lift in order to protect the safety of Canadians?
Mr. Clement, it's a fundamental responsibility of government to monitor its programs and its activities. That is especially true in the field of public safety and security. And we will be examining very carefully all of the activities we undertake to make sure that we're accomplishing the objective that this department has the responsibility for. And I'm happy to share our progress reports with the committee. I suspect from time to time the committee may ask the question, but even without being asked the question, we'll be happy to keep you posted on the progress that we're making. In relation to opioids in particular, if I could, not related to any particular situation, but let me just make 3 or 4 points.
If you could make 1 or 2, I don't know how much time I have left.
Well, okay, maybe we'll come back to opioids.
Well, you can have another half minute. Take it.
Well, we're looking at the border measures that are required to be effective at the border. CBSA and the RCMP have already interdicted a number of shipments, which shows a pretty impressive capacity already to exercise those kinds of controls. But we're looking at what else needs to be done to strengthen the situation at the border. And as you know, we're already engaged in a diplomatic initiative with the Chinese in particular to get international cooperation to stop this scourge at the source.
Thank you.
Merci. On continue avec M. Dubé pour 8 minutes.
Mr. Dubé, 8 minutes. Thank you very much. Thank you very much, Mr. Chairman. Thank you, Mr. Minister, for appearing today. I'd like to come back to the decision by Judge Noel on the CSIS. You spoke to the media the day after the decision was rendered, and one thing you responded when asked if it was appropriate, are those individuals who are not particularly threatening to the national security. You said it would have to be examined more closely, that you were prepared to hear both sides of the issue and to see how to go forward. What concerns me somewhat in that statement is I hope that you're not opening the door to renewing the possibility of retaining all this data, which is no concern for people who do not threaten national security.
All of the facts of the matter, Mr. Dubé, to determine what the appropriate policy should be going forward. As you will know, Mr. Justice Noel himself commented on the fact that the legislation might be needing of an update since it was written at a time when I guess the fax machine would be considered groundbreaking technology back then. Things have changed since then, so he raised the question of whether or not the legislation itself needed an upgrade and a modernization. We will consider all of the factors that are relevant in these circumstances. Indeed, the national security consultation that we launched some months ago is examining a variety of these questions.
If I may, because my time is limited and it's the only crack at this I'll get. You're not closing the door then to the possibility of this happening again, because to me it seems that if the federal court has deemed this illegal, then the answer should be clear. And if you do want to update the legislation, wouldn't an appropriate proposal be to make sure that CSIS has the statutory obligation not to retain data on people who are not considered threats to national security?
Well, I'm receiving advice from a lot of Canadians about all of these issues. And when we put that all together in the national security framework, we will report to Canadians on what the result is. But bear in mind that there are two objectives for this consultation. Number one, keep Canadians safe. And number two, equally important and simultaneously, safeguard the rights and freedoms of Canadians in an open, inclusive, democratic society, and that includes their privacy rights. And we have had some very important advice offered just in the last number of days from Commissioner Terrien, the Federal Privacy Commissioner, and a number of his provincial counterparts. And I take the advice coming from the Privacy Commissioner very, very seriously.
Mais donc, si on veut protéger la sécurité,
If we want to protect security and ensure rights, it seems to me quite clear that we will not allow the retention of information which is a breach of privacy, particularly of individuals who pose no threat to national security. Well, I'm sure that's not the last time that we're going to be discussing it. So, but on the same subject, I also have another question for your colleague, the Minister of Justice. But in her stead, perhaps I'll ask it to you. Departments have gone to court to defend what was being done by CSIS. Were you and was your colleague aware of this defense being mounted by the Department of Justice?
so the Justice Department's lawyers going into court, omitting certain information and defending this scheme by CSIS. Were you or your colleague or the Minister of Justice aware of this?
The Director of CSIS and the Deputy Minister of Justice, in addressing this question, have both said clearly and unequivocally that until the federal court made its ruling, they were of the view, based upon their own legal advice, that the procedures being followed by CSIS were in fact authorized by the statute.
So you were not aware?
No. The first time this issue came to my attention was in the SERC report for 2014-15, which was filed in Parliament in January of this year. You remember it should have been filed last year, but it was delayed because of the election.
So between January and the court ruling, and then the media coverage that followed, there's several months there. What happened in the meantime? So you were aware in January, and then the decision comes out later. Did you have a discussion with CSIS? How did this play out?
The SERC report flagged the issue. It was after the issue had been raised by SERC that the federal court began its further examination of the issues that were involved. The service and the Department of Justice were dealing in an ongoing way with the federal court, responding to their questions, providing them with information, and that was an ongoing process over a period of several months.
So was data retention still ongoing, or was there a moratorium put on while these court proceedings took place? What exactly happened? I'm still unclear on that.
When the issue was fully elaborated on by the court was when Mr. Justice Noel provided us with a copy of his judgment. And when I had the opportunity to read his judgment, I immediately called upon SERC to, since it was the body that had raised the issue in the first place, to re-inject itself in the situation and to make sure that the judgment of the court was fully and properly enforced. And Mr. Colombe advised me that in fact was the case.
Est-ce que vous trouvez que c'est inquiétant que vous arrivez en poste?
Don't you find it somewhat concerning that you come into the position of public security and you're not aware of the actions of an agency that comes under the coverage of that particular department?
The service and the Deputy Minister of Justice were dealing with an outstanding legal issue. They informed me that they were responding to the questions of the court, they were providing information, they were collaborating with the court in every way to provide the information that was required. This was an ongoing procedure. When the court finally issued its opinion on the subject, which was at the, I guess about the middle of October, I believe, that's the point in time when I had the opportunity to read the court's judgment. And the court said, as you have reported, that they found this, this particular retention of associated data to be without legal authorization in the statute. And it's at that point that, that the director of CSIS took the immediate step to stop the practice, and I invited SERC to re-involve itself in the situation, to supervise and to make sure that the data was properly taken care of in accordance with the judgment of the court.
Parfait. Juste une dernière question, si vous me permettez, avant que mon temps s'écoule.
And one last final question before my time expires. According to the Natural Resources Minister, can you give us your reassurances that there's no surveillance of Aboriginal activities, protests and such, environmental and Kinder Morgan situations? We've learned that, in fact, that there was such surveillance going on in the past, and can you assure us that this is no longer the case? It's not going on as a sort of preventative measure?
The absolute assurance that we made reference to in our election campaign, and that is that peaceful protest and demonstrations and advocacy are fundamental rights in Canada. They're protected by the Charter, and if necessary, we will change the law to reinforce those rights, to make it absolutely clear that Canadians can exercise those democratic rights without fear in this country.
We'll follow up on that. Thanks, Minister.
Thank you, Minister. Mr. Mendicino.
Merci, Monsieur le Président. Minister, thank you very much for your remarks this morning, or I should say this afternoon, on these supplementary estimates, and for taking a moment to expand on a number of priorities which relate to your portfolio. It's quite clear to me, as I would think it would be to all members of this committee, that there is a tremendous amount of work that is being done on the portfolio, and for that we are very grateful. You made a recent announcement with regards to the Security Infrastructure Program, and for those who are unaware, this is a program that is designed to help communities who are at risk of hate-motivated crimes to improve their security infrastructure. Could you take a moment to tell us how you've enhanced the criteria and the eligibility of this program in ways that improve on the old model?
Thank you, Mr. Mendicino. This is not an expensive program. It costs about $1 million a year, so it's not a program that involves a huge amount of public funds, but it is a very useful program for groups and organizations who feel themselves vulnerable to hate crimes. And sadly, we have seen in recent weeks and months some very painful examples of that. We've had some pretty brutal graffiti, vulgar in its nature, quite crude in its dissemination of white supremacist symbols in my own city of Regina, here in Ottawa. In Ottawa, there were 4 places of worship that were subjected to this kind of attack. We've seen it in Toronto, we've seen it in Peterborough and other places across the country. And groups and organizations that feel themselves vulnerable have, over the last number of weeks and months, made the point that the Security Infrastructure Program, while useful, could be made more useful without costing a lot more money, and that's by changing the terms and conditions of the program. So we have broadened the eligibility requirements. one of the previous rules was you actually had to have suffered an attack in the past in order to qualify for the funding. And the funding is available for gates and fences and security film on windows, closed-circuit television, cameras, lights, those sorts of things that contribute to public security. But in order to be eligible for it, in the past, you actually had to have had an attack, which is kind of like after the fact. So we've changed that. Obviously, if you have had an attack, you're still eligible. But now, if you can demonstrate your vulnerability in advance by objective evidence that shows that you may be vulnerable to this kind of danger, you submit that argument to the Department of Public Safety. And the officials will make an assessment. You can actually, as a part of your application, get an external opinion about the vulnerability. So that's one important change. Another change is to make the security infrastructure expenses applicable to the inside of a building and not just the outside of a building. Previously, it was just the outside perimeter. Now it can include infrastructure changes within the building. And the third thing we're doing is making sure that communities that may well feel themselves vulnerable are well informed about the program. We're involved in a communications effort to reach out to groups and organizations to let them know that the program is available and that they're eligible to apply if they think it would be appropriate and necessary.
And I will certainly do my level best to help educate the members of my community on this program, because this is an issue that has come up in my riding as well of Eglinton Lawrence, so we are grateful for these enhancements. In my remaining few minutes, I'd just like to ask you to expand for a few moments on the Fort McMurray fires, which you characterize as being one of the worst natural fire disasters in the history of the country. You mentioned that we have matched in these supplemental estimates to the tune of $154.5 million of contributions made to the Canadian Red Cross, and that before that there were $307 million set aside in the annual disaster relief fund. Can you tell us how those funds will be used to help the community in Fort McMurray recover from this terrible disaster?
The two programs are designed, the matching funds and the DFAA, the two separate programs, are designed in a way not to overlap with each other or conflict with each other. The funding through the Red Cross is aimed at those sorts of things that DFAA would not cover. So there are three sources of assistance here. One is the official disaster financial assistance arrangement, where, according to a preset formula, depending on the magnitude of the loss, a portion of the loss is paid for by the province of Alberta, a portion of the loss is paid for by the government of Canada. And the bigger the loss, the larger percentage the federal government pays. So far, federal and provincial officials have identified $307 million that the government of Canada will need to contribute to the province of Alberta. That is not the final calculation. That is an advance payment. So far, it's $307 million. And as the work goes on to rebuild the community, and the losses are identified in more precise terms, losses that aren't otherwise covered by insurance, the tally will no doubt continue. It does take usually some years for these things to be totally tallied up, but we were able to put into the hands of the province of Alberta within 1 month of the fire $307 million to begin the process of supporting Alberta in dealing with the situation. The Red Cross money is aimed at things that would not be covered under the DFAA. And the Red Cross has done an amazing job. The total funds that were donated, that they were able to collect from generous Canadians across the country, was $185 million. The federal matching was $104 million, and there was provincial matching on top of that by the province of Alberta for another $30 million. So the total in the Red Cross Fund is $319 million to assist those impacted by the fires, including $227 million to support individuals and families, $50 million to support community groups that are involved in the rebuilding and the rehabilitation, and $30 million to support eligible small businesses.
Thank you, Minister. Mr. Miller.
Minister, always great to have you here. And,
thank you, Larry.
Lady, gentlemen, thank you to all of you for being here. Last week, Minister, we had the corrections investigator at committee, and we questioned him about the review that was being undertaken, and one of those recommendations out of there was to increase inmates' pay. And I guess I think there'd be many Canadians that would be kind of dismayed that any kind of allowance or pay would go out to prisoners. But he seemed to be under the impression that this increase is necessary, and he's quite content that inmates never use their pay, quote, to purchase illegal drugs. Do you agree with that?
Mr. Sapers, I think, is very well positioned to examine the facts, and his advice is that a very small amount of funding is not, in fact, used for any illicit processes.
Okay, is there documentation, study that shows that? And if so, could the committee get a copy of that?
Perhaps I could ask Fraser McCauley to comment on that from the point of view of the Correctional Service. And Fraser, if you could also just describe the amount of money that's involved, which is relatively small. And again, remember that this was a recommendation from Mr. Sapers, and I have simply passed that recommendation to the CSC and invited them, as Mr. Sapers had asked, for this issue to be investigated. So it's under investigation. It's not a decision that has already been taken.
Okay, thank you. And my next question was going to be for you anyway, Mr. McCauley, so we'll continue with that.
So, yeah, we would have to take an undertaking to go see where he has determined those facts, because I can assure you that we don't have a breakdown of the complete spending of their funding to that level, but we would be able to do that.
Sure, I appreciate that. My next question that was going to be for you still is we hear all the time, and even Mr. Sapers was around it, that there is a drug problem within prisons. Some of it illicit drugs, some of it, for the life of me, I can't figure out how or why, is prescribed drugs. But there's a problem there. So how do we fix this? I don't think it's a perceived problem. I think it is a problem with the amount that you hear about it. So comments?
Yeah, so there is no doubt that there are several inmates who come in both with substance abuse issues and or casual drug usage, and that during their time in incarceration, whether it's using medications and or other illicit means to get drugs in, that is done. That it's an ongoing issue for us. We follow very strict plans, from our searching inside to education to actual health interventions to programming interventions. So we're following the same as any outside public domain would, attacking the issue from three components. But yes, there is no doubt drugs do get in. There is an active market for people who are seeking that relief, both inside and outside of institutions, and it is an issue that we attempt to deal with as much as we can.
Okay, on the drugs getting in there, Mr. McCauley, you know, in this day and age of technology and what have you, security, you'd think that you could pretty well stop it if the will was there. Even if they were coming in, let's say, by drones. I would think that before the prisoners are let out for their daily exercise outside, that security would check the yard to make sure that nothing's been dropped in. So, it's pretty hard for a layman or the average person to figure out, if we really want to stop it, why aren't we? And I'm not, pointing fingers, but it just would appear to me that it should be able to be stopped.
I don't disagree from a perspective if you talk to the average person and their beliefs of the prison system and the incarceration levels and the security levels that we have. Unfortunately, where there's a will, there always appears to be a way, and there are illicit drugs that get into our institutions, whether it's through personal importation from people going in and out of the institution that we're missing during our searches. As an example, the new synthetic drugs are very hard to stay atop of, even from a technical perspective. The more we change our formulary to pick it up, quickly the same issues get picked up and different types of substances are being done. So it happens, but it's not obviously what we want to happen.
Thank you, Mr. You're having fun.
Thank you.
Thank you, Mr. Macaulay and Mr. Miller. Monsieur Diorio, vous avez 5 minutes.
Merci, Monsieur le Président. Monsieur le Ministre, je vous remercie.
Thank you very much, Mr. Chairman, and thank you very much, Mr. Minister, for the preparation of your presentation today, and all those who helped you. We thank them as well. I'd like to talk about border services, customs, the problem that I might call the 3 A's. That is, in English, welcome, appearances, and expectations. So let's talk about the welcoming. Those who attend our borders, who have to deal with the border personnel, are either Canadian citizens who are returning to the country, or they are not Canadians. And it seems that there's a certain welcome on behalf of the welcoming aspect when they arrive at the border. And then there's appearances. When we attend at the border, we see that we're faced with a very militaristic look. They are in uniform, they're armed, and there might be a problem there. One-size-fits-all approach. It's one thing to come to the Montreal airport and another to land in some smaller airport in rural vicinity somewhere. And the third issue is that of expectations or waiting. He's coming back to his own country, and we have him wait to enter the country. Line up and wait. So I brought this to your attention earlier, but I was wondering if you could enlighten us somewhat as to possible solutions that might be proposed by your government to deal with these 3 issues.
The Canada Border Services Agency has an incredibly difficult and important job to do. They are charged with the responsibility of maintaining security at Canada's borders. That's a serious business. The safety of the country depends on them making the proper judgments at the border about what comes in and who comes in and what doesn't come in and who doesn't come in. That's a really profound assignment. At the same time, they are making decisions at the border that have a huge impact, good or bad, on the Canadian economy. Just thinking of the border between Canada and the United States, there are 400,000 people who cross that border every day. And it's about $2.4 billion in trade. that crosses that border every day. So CBSA is a fundamentally important organization. They have to get it right. So there's a real seriousness about this job. At the same time, you make a valid point that when Canadians are returning home or when newcomers are arriving, they want to feel that they're being treated professionally and politely and in a welcoming fashion.
Et à cet égard, Monsieur le ministre, ce qui m'interpelle, c'est que...
And in this regard, Mr. Minister, is when I travel to China, for example, they haven't had elections there in a while, certainly not the type of elections we have. I'm welcomed more warmly than in my own country. They're not dressed as army or military, but in this country that's not what we see. So one size fits all. It seems that we take the highest degree of security required for the worst situation, and we have border agents who see 400,000 people go by the gates, and yet they cannot seem to be able to separate the wheat from the chaff and see who can go through quickly.
It's a careful balance, Mr. Delorio, and Canadians would be pretty unforgiving if they found that the system in some way didn't serve them well on the security point of view. At the same time, there needs to be that human element that also is welcoming and polite. And maybe I could ask Carolyn Xavier just to comment on this, because these are kinds of questions that she has to deal with every day.
Oui, merci, ministre. Juste pour vous dire...
Thank you, Mr. Minister. Yes, well, we invest heavily in the training of our border agents and officers, and we ensure that they behave in a very professional way. Client services is very important. I know, well, when you were comparing Canada and China, if you take a look internationally, how or where we can improve our border services, we do so daily, and we're very, very proud of how we do serve our publics. There's always room for improvement and learning. Obviously, things can be improved and changed. We can learn from other border services how we can improve that. We appreciate the feedback that you've given us today, and we also are aware of a number of positive comments that are made by travelers who return from abroad. Now, as the Minister just mentioned a few moments ago, in security terms, let's not forget that we are the very first contact that the public at large has with this country. I appreciate that you may see the same person on a daily basis, and like say the Nexus program, frequent travelers who are frequently passing through the border back and forth, and they come through with more facilities. Thank you very much. I believe that the time has arrived. We've come to an end of our allotted time.
Okay, so we'll just make a note of that in minutes. We'll do that. Thank you. Merci pour tous les témoins. Thank you for your time and for your testimony, and we'll take a brief pause as we change to go to the second hour. Very good. We're going to continue now with the second part of our meeting, and it was at the request of the committee to spend a little bit more time with officials from CSIS, and we're very pleased that the director, Mr. Colombe, is here with us, as well as Mr. Cousineau, who is here as the deputy director or assistant director, and welcome from the Department of Justice, Mr. Frater, Chief General Counsel. I understand that the director has a statement, and members should have copies of it, and we'll give them time to make a statement, and we'll proceed to questioning. Welcome.
Merci beaucoup, Monsieur le Président. Merci.
Thank you very much, Mr. Chairman, and thank you very much for the opportunity to talk to you about a very important decision. As Canada's National Intelligence Service, CSIS mandate is to identify, investigate, and advise government of threats to the security of Canada. In order to fulfill our mandate, CSIS depends on a range of investigative techniques. However, irrespective of the techniques employed, operational activity must be authorized, reasonable, and adjusted to the conditions and proportionate.
Approval of the minister, CSIS may make an application to the federal court to obtain warrants against subjects of investigation. These warrants, which are granted by the federal court, authorize the use of specific investigative techniques in accordance with specific conditions identified by the court as appropriate. One such technique is the interception of communications. When CSIS intercepts communication, it obtains the content as well as the associated data linked to that communication. Associated data is the context, not the content of a communication. Such data is used by computer systems to identify, describe, manage, or route communications across a network. On its own, it does not identify individuals who are party to a communication. Whereas CSIS analyzed the content of communication intercepted under warrant to determine whether or not it is to be retained or destroyed, and continues to do so, in 2006, CSIS adopted the position of retaining and exploiting associated data to enhance our ability to detect threats. It is important to note that CSIS collects this associated data legally through warrants issued by the federal court. At issue, however, is the service's retention of associated data lawfully collected under warrant, and in particular, our decision to retain all such associated data, including that which may be non-threat related, associated data linked to a third-party communications. La Cour s'est également prononcée clairement sur le respect par le service.
The court also clearly pronounced on the service's duty to candor, finding that CSIS had breached its duty of candor by not informing the court of its position on the retention of associated data and on the creation of the Operational Data Analysis Center. I can assure you that this was not deliberate. I agree that the court should have been informed earlier of our approach to the retention of associated data and the establishment of the center. Key government stakeholders were informed of these matters. Former Ministers of Public Safety, the Office of the Privacy Commissioner, the SERC, Security Intelligence Review Committee, and the Inspector General of CSIS were all briefed on the existence of this program and the value of data analytics to CSIS investigations. And clearly, the service was not attempting to keep our data analytics programs a secret.
Remarks on November 3rd, I accept the court's decision and I have taken immediate action to respond. I acknowledge the court's serious concern and I am committed to continue efforts to address them. Immediately after the court decision was issued, CSIS halted access to and analysis of all associated data. While we did so out of an abundance of caution, the service has begun to allow access to and use of the associated data of threat-related communications. We did so because the service unquestionably has the authority to retain this information, and its use is necessary to protect public safety. Efforts are also underway to develop and implement appropriate policies and procedures that clearly address the court's concern. I would like to note that the decision acknowledged the value of data analytics to the service's investigation. CSIS and the Department of Justice are also working together closely to develop measures aimed at ensuring that we meet our obligation to the court in matters of transparency and duty of candor. I would also note that, as indicated by the Minister of Public Safety, SERC has been briefed and will be reviewing the service's response to this decision and submitting a report to the Minister. Monsieur le Président, Mesdames et Messieurs, les membres du comité, je tiens à préciser que selon...
Mr. Chair, members of the committee, let me be clear. CSIS, in consultation with the Department of Justice, interpreted the CSIS Act to allow for the retention of non-threat related associated data linked to third-party communications collected under warrant. This is now clear that the federal court disagrees with this interpretation. We accept this, even though we not knowingly exceeded the scope of the CSIS Act. I wish to reiterate that CSIS recognizes the importance of compliance with the Act, as well as openness and transparency with the court. And we stress this last factor, that we should recognize the importance of compliance and openness and transparency with the court. And on that, Mr. Chair, I will conclude my remarks and welcome any questions from the committee. Thank you very much, Mr. Colombe. We'll begin with Mr. Diorio for a few minutes. Thank you, and I thank your colleagues for having presented and for presenting these situation. Mr. Colombe, I'd like to go to page 4 of your presentation, page 3 or 4, depending on English or French. Page 3 in English, probably. So you say, members of the committee, the penultimate paragraph on page 3. Has the law changed, Mr. Coulombe, since the court's decision? Because when I read this, I'm reading that the law did authorize the retention of non-threat related. No, it says interpreted. We interpreted. Okay, I wanted to make that clear. The interpretation of the Act by CSIS is, of course, advised by legal counsel, legal opinion, and this goes back to 2005 at least, if not before that. Okay, so I understand that this interpretation was rejected by the federal court. Yes, exactly so. Are there elements of the court's decision that gives you a right of appeal, perhaps? There is a right of appeal, but we accepted the federal court's decision without appealing it. Now, I'm not asking you the question to harass you or to mislead you in any way, but I'm trying to understand. Don't you think it may have been useful to have perhaps some clarification by the court on this issue, on an issue such as this? Perhaps a Supreme Court, 9 judges, 9 perspectives, perhaps a more complete, more comprehensive overview and evaluation and analysis of this kind of situation. Well, I think I'm going to have to refer this to my colleague. And if you'll allow, I will answer in English if I may. Please, go ahead, no problem.
To appeal or not to appeal, and this is a very long judgment that deals with a lot of subjects. A large number of the subjects dealt with were dealt with to our satisfaction. It was primarily about setting terms and conditions for warrants going forward. We were quite satisfied with that part of the decision. The part of the decision dealing with the duty of candor, we acknowledged to the court that we'd breached our duty. Ultimately, I think what the court was saying was there should perhaps be more clarity in the legislation rather than seeking clarity. We always have a choice about seeking clarity. Should it be done through legislation or litigation? And our choice here, I think, is in some measure about what should be the subject of legislation and what should be the subject of further clarity through litigation.
Okay. Donc, je vous remercie, Monsieur Frater. Donc, Monsieur.
Thank you very much, sir. So, Mr. Coulombe, picking it up where I left off, CSIS sought out some legal advice and opinion whether or not a project is in compliance with the law. If you have to do with collection and retention of data. You do so in good faith, in compliance with the law. And individuals over a certain period of time acted on that advice for how much time? Well, the program was created in 2006. And Justice Noel's decision came down in 2016. So 10 years. All right, so this was going on for 10 years. When the decision came down, then your service went to the far side of that assurance. Well, listen, the decision deals with a certain aspect or part of the associated data that we collect as part of a process. Once Justice Noel came down with his decision, rendered his decision, we stopped the analysis of this associated data, and we put in place certain mechanisms to be able to resume with the program as designed, leaving out these parts of the judge. Well, if I take a look at page 2, you were saying that at the time we had the Minister of Public Safety, the Commissioner, the Office of Prisoner Privacy, the SERC, and the Inspector General of CSIS, who were aware. Yes, they were made aware of the existence of the program, 2006. Why would the Commissioner of Privacy, Protection of Privacy, not respond? Well, no, the Justice Noel said he had no comment to make as to the position taken by the Office of Privacy Commissioner on that. No, no more than that. No, you're being reproached for the lack of candor and transparency. And yet you went to the Privacy Commissioner and you let him know what was going on. Well, Mr. Fraser can address that point, but the court's decision and comments on transparency and our duty to candor was vis-a-vis the court, not vis-a-vis other departments, whether it was CERC, Inspector General, or Commissioner. We were not delinquent in our duty. We were delinquent in our duty to the court, perhaps. The intention of our service, of CSIS, was not to try to hide or dissimulate the existence of this program. It was strictly... Now, on the various requests you've made to the court, how many failures were there to exercise the duty of candor? Well, since the onset of the program, I believe in 2011, there was a... This is in Justice Noel makes reference to this. The existence of the program was mentioned, but perhaps in a sort of dilatory fashion, rather in passing, and the court was perhaps not in a position to understand the extent of the program and the fact that we were retaining all associated data. Thank you. We were going to continue with Mr. Clement.
Just want to make sure I understand exactly what's going on now, Mr. Coulombe. You still retain the information but have closed access to it? Is that right?
Yeah, in terms of the information that is subject of the ruling, it is still retained, but nobody has access and nobody can use it in terms of doing analytics.
And then you say efforts are also underway to develop and implement appropriate policies and procedures that clearly address the court's concern. So are you working on a policy that would then regain access to the information consistent with the court judgment? Is that what you're working on? Or why are you keeping the information if you don't have access to it, I guess is my question.
Well, we're keeping it maybe important to note that Juge Noel did not order the destruction of the information in question. And at the moment we're keeping it because as we continue our analysis of the program, of the decision, what it means for the impact on the organization. But there could be also other reasons why we don't want to destroy at this time that information. And maybe, I don't know, Rob, if there's anything you want to...
No, it's
Sorry, are you saying something?
nothing to add.
Yeah, I'm sure. So I'm just trying to figure out, like, let me just play the theoretical here. So is that information theoretically hackable?
No.
Why would you say that?
Because our systems are not connected to the outside.
Okay, what if you have somebody from the inside who has access?
Well, there's always the insider threat, yes, but again, there's a number of measures the service is taking, not just with that specific data bank, but in terms of all of our holdings, in terms of mitigating the risk of the insider threat.
So the risk is mitigated, but it's not impossible.
Like any risk, you cannot say you'll bring it down to zero.
Right. So as a citizen, basically where we have to be trusting in your ability to be perfect in order for this information not to be somehow misused by nefarious forces in the future?
As I mentioned, there is a risk. You cannot bring that risk to zero.
So I'm just, I do want to register, Chair, my disquiet for not understanding why the data is still in the system when the commissioner has made it clear he understands that the court decision means he doesn't have access to that information. So
Well, I can give you one example.
Please.
I can give you one example as why we're doing further analysis. The information that is subject to that decision, let's say there's a piece, some of that information was used in any type of proceeding in the context of the criminal case or in the context of administrative case. We destroy the information, and then if we go back to Sharkawi 2, the Supreme Court decision that told the service, when you're using information in a court context, criminal and administrative tribunal, you have to retain that information. So before we rush and destroy that information, we have to make sure that by destroying it, we're not going to be contravening another court decision, in this case the Supreme Court decision known as Sharkawi 2.
That's a perfectly reasonable example. So what percentage of the associated data relates to that situation?
Well, that's what we're trying to do now. It's extremely complex to go back into that, and I can ask John to explain why, to go back in that data bank of associated data and to do that analysis of what is threat related, what is non-threat related, what was used before, what was not used, what could be safely destroyed. So we have to take the time to do that analysis before, again, we start destroying, if that's the decision, to destroy that information.
So you're going through the analysis to decide if the data, if a subset of the data can be safely destroyed, but you haven't made the decision to safely destroy the data. Who makes that decision? The minister?
No, it would be me. That would be obviously informing the minister as things progress, informing the minister, and like the minister mentioned, he has asked CERC to review what we're doing as a result of that decision and to report back to the minister.
Okay, but it sounds like you haven't made that decision yet, so
No.
the data is still there. So what does this operational data analysis center do if you don't have access to the data?
You want to go?
Good afternoon, Mr. Chair. Thank you for the opportunity to appear before the committee today. As Director Coulombe mentioned, associated data and intercept is only but one means of collecting information that the service has. So advanced analytics applies to, it's used to essentially maximize the value of information that the service collects. As you can imagine, given that we have other programs that collect information, the advanced data analysis in ODAC is still undertaking an analytic work to help move investigations forward, just simply not looking at associated data.
Okay, so that it does other things of analysis not connected to the associated data, and does not need the access to the associated data to continue its analysis on other matters.
Correct.
Okay. There's something else. So I want to go back
Just
to your
very briefly.
description of the data on page 1 of your remarks, where you say the data is used by computer systems to identify, describe, manage, or route communications across across a network. So could you just be a bit more specific as to what exactly we're talking about here?
So associated data is data about a communication. It defines not the content of the communication, but it defines the communication event. And the purpose of associated data is to help the network route the information through the network. So a very simple example would be associated data would be a phone number, so the number that is called. Well, the reason that associated data is there is to actually route the telephone conversation to the right destination. So that is what we were trying to explain when we said that associated data is used by the network to actually deliver information. And again, to reiterate, associated data does not describe the content of the communication. It simply describes the context. Classic examples: date, time, duration, phone number dialed, etc.
That's it.
Okay.
All over.
Monsieur Dubé.
Monsieur le Président, j'essaie de réconcilier.
Thank you, Mr. Chairman. I'm trying to understand the definition that the court has of the associated data, because I have it here in English. They've decided that collected through the operation of the warrants from which the content was assessed as unrelated to threats and of no use to investigation, prosecution, national defense, or international affairs. And when I take a look at what you've said, when you speak of associated data, connect as to threat-related, it seems to be somewhat of a contradiction. Well, in his decision, Justice Noel has said that the definition that he assumes for associated data does, in fact, vary from that which is found in the Act, and that does lead to some confusion. Oh, go ahead. What we define as associated data, if you take a look at the part that Justice Noel says we cannot retain, that's what he calls associated data. Well, if we follow along the line of thought that Mr. Clement was putting forward, the decision to retain or not retain, and which parts, and its analysis, if you don't have the same definition as that used by Justice Noel, how can we possibly be reassured that you're not simply allocating those portions of data that Noel is talking about? Well, we're modifying our procedural policy. We're adjusting it. We're adjusting our terminology to begin with. That's one thing. But regardless of terminology, Justice Noel's decision is clear. If it's not threat related, if it's third party, we are not authorized to retain it. Label it however you like. Associated data or non-pertinent, whatever. We're looking at the decision. And the decision deals with what? It deals with third-party associated data garnered at the same time as any communication. I know that there's some difficulty with lack of... so if you're reworking your terminology, how do we address the problem that at heart, data was retained using one definition, and now a legal decision has come down saying that this isn't legal, but using a different definition, but you're still keeping the data, you're still retaining it. No. If we take that data bank that contains all of our metadata, all of it, a subset of that is what is the object of the decision of Justice Noel. Once he rendered his decision, we stopped analyzing that data. We have allowed access to data which we clearly identify as threat-related, obviously. So threat-related data maybe we are authorized to retain that. So we are allowing access, and so how do you determine which are threat-related and those are not threat-related? I'll leave that to John, because if it's threat-related, there's an operational report, and we can make a link, a concrete link operationally. So we go back to the operational report, we find that associated data that was used, and that's how we reestablish its threat-worthiness. Well, I really can't add too much to what the director has just said. It's a comparison to see if there's a report created. If an operational report was created, then we can associate some conclusion of that operational report with some associated data. Therefore, it is threat related. If we cannot clearly establish that it is threat-related. We will take the prudential approach, and we will leave it in that subset which is deemed non-accessible. Well, my time is very limited, so I think I'll change my line of questioning here, although I'm still confused. When you gave us that list of those who were advised of this, you said former ministers of public safety, and perhaps Mr. Goodale was only informed because of a report by SERC. What of previous ministers? Well, we did advise ministers of public safety. First of all, we were implementing a new program, so we had to advise a minister of that, of course. And over the course of the years of the time, the program was in our annual report that CSIS produces and provides to the minister. The program is mentioned, obviously. And in the past, ministers were advised through the annual report, through my annual report on the service, and Minister Goodale, as his predecessors, could consult our annual reports. The CSIS, no particular briefing for a new minister. Well, yes, of course, briefings occur. But the program we were talking about is one program among quite a plethora of programs.
Mr. Frater, I just want to know, I don't know if you're can answer this question, but was the current Minister of Justice aware of the arguments before the court that were being made by the Department of Justice about this data retention?
She was briefed on the litigation generally. On the specifics of the argument, I don't think so. I don't recall whether she was given a copy of our written submissions, but she was generally aware of the litigation.
Okay, thank you. Monsieur Coulombe, juste en terminant avec les quelques secondes qui me restent, vous avez...
Closing with the little time I have left, I'm sure you don't have the information at hand, but if you could supply it to the committee, I'm very curious to know the percentages of individuals, number of individuals, the percentages of associated data in terms of the number of investigations. What part is non-threat, threat? We'll do our best to provide that, but given the architecture of the program and its database, how many persons are involved, we have to figure that out first of all. And well, perhaps you can look at that with the architect of the data. Well, look, we gather data. It's all put into a data bank. It's not associated with individuals. It's email addresses, it's URL addresses, it's phone numbers. So how many individuals does that represent? Isn't that where it goes off the rails? When you start looking at people who are absolutely no threat because you don't know who you're dealing with. Well, exactly the analysis that we have to conduct.
All of you for being here today. Following up on something that Mr. Dubé started asking you about was previous ministers. I note that this practice started 10 years ago in 2006, which is the time of the previous government. So the previous Minister of Public Safety was briefed on the creation of this practice, and I'm assuming that he approved of it?
Well, I would have to go back. I don't think at the time we were seeking his approval. We were informing him that we were putting in place that
But he
program.
didn't ask you to stop?
No.
And then he was briefed on it annually? Is that what you said?
Well, not just that minister, but on a number of occasions, and if you give me a second. For example, from 2007 to 2010, the service actually described the program and what it was doing. In its every year, the director has to submit a classified report to the minister. So from 2007 to 2010, ODAC, that program, was mentioned in that report. In 2010, again, there was also a verbal briefing given on ODAC and its usefulness to the minister at the time.
Okay, so no one asked you to, during all those years, that questioned the privacy of the information and whether we should be, whether you, not we, whether you should be doing that then?
Well, I cannot comment if that question was asked or not. At the time, there's no documentation.
Okay, no, that's fair. So our current public safety minister was sworn in December and then found out about it in January when SERC released their report. So what did the current minister ask you to do when he found out about the SERC report?
Well, the SERC report, what the SERC report said, the SERC report didn't say what you're doing is illegal. The SERC report only raised the issue that, according to SERC, the service had not fully briefed the court, the federal court, on this program.
Okay. So did our minister had mentioned something today about asking you to take some measures when he found out about it?
Well, when he found out the court decision.
Okay.
When the court decision came out this fall, then the minister, and actually we had already taken measures such as stopping access and analysis. That's what the...
Okay. So this is metadata, right?
Yeah.
And we had talked about that before.
Yeah. Just to make it even more confusing, metadata
I know, because you know that term kept coming up a lot, and I think you described it as nothing more than the outside of an envelope. You and Commissioner Paulson. It's a little more.
I don't remember exactly what I said. I remember saying the envelope. I'm not sure if I said nothing more.
It may not have been you, in fairness. I just remember the two of you trying to describe it. It could have been Commissioner Paulson at the time.
No, and I don't want to put, what I'm saying is I remember one of the two using it. It's like the address on an envelope. It's the nothing more, almost minimizing the importance of metadata, which is certainly not, was not my intent if I said.
So we've had a lot of testimony since then, as well as on another committee that I sit on where we're looking at cyber violence. Yep. That metadata is a lot more than that, and you can actually get an awful lot of information from that associated data or metadata. So I guess where I'm going with that is, I mean, you were collecting this information on innocent people for 10 years, and you still have it now, right?
Yeah.
It's just not being accessed. You've had the ability to share that information under Bill C-51. Was any of that information shared with other departments?
The only information out of that metadata associated data bank, the only information that we would share is when we've done analysis and we can link a piece of that metadata to a threat.
Okay, because CERC only looks at you, not the RCMP yep. and the other agencies, yep. right? So I'm just wondering whether any of that associated data was shared with other agencies that wouldn't have been subject to the CERC review.
No, we wouldn't share raw metadata with other agencies. Like I've said, we would only share it once we've made the link between that metadata and a threat-related activities.
Okay. So I know there's been some discussion about whether or not the Act needs to be changed. You're yeah. doing your own policies and procedures. So one of the things that we're looking at is making sure that we're also retaining, respecting people's privacy, while at the same time ensuring that Canadians are safe and secure. So do you see anything that you could recommend that we could be putting in changes to the Act that would help us to do that? Or am I putting you in a difficult position?
Well, I think what I would say is the National Security Framework Review that is ongoing is the place to have that discussion, because it is to achieve those two objectives, keeping public safe and also safeguarding our rights and freedoms. The only thing I would add to this, Juge Noël was clear on 2 points, that it was probably time to review the CSIS Act after 33 years. But also, very important, because at one point somebody mentioned the non-threat related metadata is destroying it or not using it would have no impact on national security. Juge Noël actually acknowledged, after seeing the evidence, the usefulness of that program. And what people need to understand is a piece of data that is non-threat related today could actually help us connect the dots or make a links a year from now.
Yeah,
Which I'm not arguing that,
no.
but all I'm saying is before we make a decision, we have to have all the facts and really understand the potential usefulness.
No, I understand that. It was explained to me that it's like putting security cameras in someone's house all the time in case there might be a crime. So, you know, people can relate to that. I think when you're talking about data and associated data and metadata, it's all like speaking a different language to people. But if you think of it in those terms, most people would say, I don't want cameras in my house 24 hours a day just in case somebody might break in one day.
I totally understand that. My point now here is that I am telling you on the other side, it can be useful. Now, the decision to keep it, use it, or destroy it because of privacy consideration, that's a public policy decision.
Yeah. And my time's up. I think.
Miller for 5 minutes.
Much, Mr. Chairman, and again, gentlemen, thanks for being here. Mr. Colomb, I want to continue on about the potential eventual destroying of the data. But before I do that, I just to read one of your last paragraphs in your opening remarks. You said that in consultation with the Department of Justice, you interpreted the CSIS Act to allow for the retention of non-threat related associated data linked to third-party communications collected under warrant. Is any of this data stored or solely with the Department of Justice, or is it all within your department?
No, it's all with CSIS.
It's all within. Okay, that's good. Now, have you any idea along timelines when the decision to destroy or not destroy will be made?
Do we have any? If I was going to give you a timeline, it would just, I can't at this point. It is a very complex, not only decision, but it had really,
within 6 months, within a year. That'd be.
I would hope that within 6 months we would be in the position to decide what should we destroy it and what should be destroyed.
Yeah, no, that's fair enough. I mean, I realize there's a lot of factors in it. Now, when it comes, let's say that the decision is made to destroy it, I want to go back to a scenario back when the long gun registry was legislation was changed, and it was eventually ordered that that data be destroyed. And the order was made, and we were told that it was. But it was very obvious to many of us that after the fact, I'll just say some provinces or some individuals obviously had a copy of it or part of it. We don't know. And the reason that I say that is very, I can get the data or information to back this up, is that too many related instances on firearms about individuals came out when they went to renew this kind of thing. So what my question is, how does the average Canadian out there, once the decision is made that this information will be destroyed, how can they be 100% sure that it's going to be destroyed and what have you? And I'm not suggesting that you would do otherwise, but sometimes there's a lot of people who have their fingers on the button, so to speak, Mr. Colomb, and you're not the only one. So.
Yeah, no, that's a fair question. That specific data bank is actually centralized in headquarters, and the number of people who have access to it to do the analytics is restricted. So it's not accessible by all CSIS employees. If and when the decision to destroy part of that data bank is taken, again, CERC has been tasked by the minister to monitor or respond to the federal court decision, and I am certain that would be one aspect of or reaction to that decision that CERC would review.
So, okay, just to carry it a little bit farther, is it safe to presume that there's probably more than one copy of that information, you know, for safety? You know, it's like like me renting a safety deposit box in a bank, you know, for you know, important documents. The same kind of scenario take out in the case of this?
Yeah, we have backup of that data bank in the event that, for example, something would happen in headquarters, some natural disaster. So yes, but again, we would procedures, and if we were to destroy, we would make sure that the backup banks are also destroyed. And again, CERC, I'm sure, would look at that.
Okay. In how much time, Mr. Chair? Half a minute. Just on that then to close out, how many people approximately within the department would be involved in the safeguarding, or at least have the ability to see that? Is it limited to 2, 3, 10? Any idea?
How many people in the mix?
So, I mean, as Director Coulombe has pointed out, the one advantage that we do have in being able to look at associated data is it has been very much a centralized program. So, as Director Coulombe alluded, the information is within the walls of our NHQ building, and we are very much aware of exactly where it is. The number of exact users that we have in ODAC isn't actually representative of the folks who would see associated data, because as I return to my previous response, was ODAC does more than just analyze associated data. How many exact people have access to the associated data? I'm going to put a number out there, but please don't quote me on it, because it may be within plus or minus a bit. I'm going to say probably 20-ish.
No, that's fair. That answers my question. Thank you very much.
If you want, Mr. Chair, we can come, if that number is really incorrect, we can come back to the committee with.
Thank you. I'm just going to take my prerogative to just ask one question, and it follows up on Mr. Miller's question, and it's really to Mr. Frater, and it's a concern I have that I have read the judgment in redacted version that we have as a public document, and the five principal decisions of Justice Noel are quite clear and unambiguous. The government has decided to not appeal the decision, has accepted the decision. However, CSIS depended upon the legal advice of Department of Justice officials. That is the decision that, they went to the lawyers that are paid for by the Crown and by the people of Canada to give the best legal advice. A federal court judge has unambiguously said your advice was wrong, and I just need to know what confidence you have as the Chief General Counsel on the advice you're giving the government on these important issues, and what steps you've taken to ensure that future advice on the interpretation of an act that's as important as the CSIS Act is correct.
Well, clearly, we always strive to give the government the best legal advice that we can, and in this situation, as in every other, we reviewed the case law, came up with a legal position, and ultimately, court disagreed with us.
But it was over a 10-year period, from 2006 till 2016. It's a long period of time to be giving advice.
Well, it's not that we're giving advice, wrong advice, continuously over 10 years. There's a question of the legality of what it was that CSIS wanted to do. We give an opinion on that, and until it's litigated, as it was here, we continue to believe that we gave the best legal advice based on the law as we understood it at the time. But from time to time, it happens that judges disagree with us. Laws are struck down sometimes when Parliament thought they were constitutional. We might have given advice that, in our opinion, it was constitutional.
Thank you. Mr. Medicino.
I think, in fairness, sometimes judges of the Supreme Court have differing views on constitutional matters, but I digress. So just to paragraph 204 of the DES November 3rd, 2006 federal court decision. I don't know if you have a copy of it handy or not. One thing I would like to clear up so that I haven't misunderstood the testimony say, though, And just reading from that passage right now, it states, quote, presently the CSIS must destroy, and then there's redacted 3 portions within a period of, and then a redacted portion from the time of collection, whether or not the communication has been assessed as threat-related pursuant to Condition 2 of the warrant. So just that one sentence does suggest that, unless I'm reading it out of context, and sometimes context is difficult with redactions, that there is an expectation by the court that CSIS must destroy something within a period of time of collection. So can you provide some clarification about that?
What you're reading is part of the new warrant conditions that we were proposing, and so and correct me, Rob, but it's basically going forward.
Okay.
But when you read the decision, there is no, the judge didn't rule on what we have now in terms of destruction. Okay, and so I'm reassured to a certain extent by that clarification. And just going forward, Mr. Colombe, you did mention during your introductory remarks that there have been discussions between the service and the Department of Justice about how to improve cooperation and reduce the likelihood or probability of any concerns around candor with the court. Can you just elaborate on how you see that cooperation strengthening going forward? Yeah, in the Juge Noel decision, he does mention in June 2016, Deputy Minister Justice, myself, we appear in front of the federal court en banc, so all available designated judges, to discuss the issue of duty of candor. As a result, Justice and us are working now on an action plan with a number of measures. And we're waiting for the final reports with recommendation as to how to better discharge that responsibility and obviously we'll report back to the court in terms of those recommendations.
So do I have any more time, Mr. Chair, or am I?
2.5 minutes.
Oh, lovely. It's a rare occasion. Okay, so just can you take a few moments then, since we have the time? Give us some specific examples about how you see this cooperation working.
You want to?
Well, the main criticism in the judgment is about our breach of the duty of candor. I don't think there's any misunderstanding in the department or in CSIS that we have to do better. And I think what the court is telling us is that for certain decisions that they're going to make, like the decision to issue a warrant, they want some more context. So we have to be careful that we are giving them enough context so that they can make a proper decision. So we have to make sure all our people are aware of that duty, both the affiants from CSIS and the lawyers presenting the case to the court. We're taking advice from outside experts on how we can do better by looking at best practices in ex parte matters in other jurisdictions.
Have you learned anything specific in studying some of the examples from different jurisdictions on?
We're waiting for a final report from our outside experts on that question, but this procedure is, warrants under the CSIS Act are somewhat different than criminal code warrants for that. So one of the things we've asked our experts is really look at what other people do in different contexts, but look particularly at this context because it is something different, and we're trying our best to come up with a plan that recognizes the unique nature of these proceedings.
Thanks, Mr. Chair.
You had another minute I was giving you. I thank you very much, the witnesses. You've answered our questions and have been helpful. The meeting is adjourned.